Good afternoon, my name is Alena Shautsova. I'm an immigration attorney from New York. In today's video, I will be talking to you about the most popular United States immigration myth. What is the truth and what is not? What can help you to get status in the United States or what will not? So thank you very much for joining me. On this channel, I share the most recent immigration news. I have live programs where I answer your guys' questions live, and most importantly, I also share immigration tips and provide my explanations of very complex and ever-changing United States immigration laws. So thank you very much for watching. Please subscribe to my channel, hit that notification bell button, and let's start. Myth number 1. If you buy real estate in the United States, it will help you to get status in the United States, or maybe even a green card. Well, here I have to disappoint you. Despite the fact that this trick is being used by many real estate agencies around the globe, in the United States, there is no immigration program that would allow one to receive a green card or any status just because they invest into real estate. No matter how much money you're going to spend here, $10,000 or $10 million, if you're simply buying the United States real estate, houses, commercial or residential buildings, it will not give you any status. This being said, sometimes there are legitimate immigration programs or visas that will cause you to have immigration status in the United States, immigrant status like a green card, or non-immigrant status as an E2 visa, for example. If you make an investment into the United States economy, but it is beyond simple real estate, usually such investments are calling for some sort of a startup, some sort of an enterprise that will also create workplaces, employment places. So it's very important to understand that. And however tempting it is to just pay money into real estate and wait for that green card, you have to know that this is not the case in the United States. It is true that around the globe in certain European countries, you can actually obtain permanent residency by investing into real estate, by buying, let's say, an apartment or condo or house or a beautiful villa, but not in the United States. Myth number 2. Once you enter the United States in legal status, you cannot change the status to anything else. And if you would like to get a different type of non-immigrant visa, you must leave the United States and apply for it overseas. Well, this is just not the case. In fact, the United States immigration allows one to legally change their non-immigrant status. Let's say you enter as a tourist and now you would like to apply for a business non-immigrant visa as an E2 and you qualify for it. So you can do that without leaving the United States by filing a special form, I-539 in most cases, and asking the government to change the purpose of your entry from original purpose to a different one. This way, for example, somebody who entered the United States as a tourist may later obtain student status or may later obtain work visa, for example, non-immigrant work visa that will allow them to actually legally engage in employment in the United States. Again, form I-539, and it is possible to file for it while you are in the United States. However, just because it's possible, it does not mean that you should do that. And that's where a skilled, experienced immigration attorney will be very helpful in advising you whether or not in your particular situation you should or should not go this route. Sometimes there are advantages of leaving the United States and applying for that visa because, for example, it's going to give you longer admission time than the one available if you change status in the United States. And finally, popular myth number 3. If you have a child in the United States, born in the United States, it will fix your status. Well, it's not always the case. It will help you to fix your status, but only if and when your child, who is a US citizen, reaches 21 years old and can petition for you. Plus, you have to show if you are in the United States at the time that you entered the United States legally, or you qualify for one of the very, very narrow exceptions to the rule that someone who is an immediate relative of a US citizen, such as a parent of a US citizen, must demonstrate that they were admitted, inspected, or paroled when they entered the United States. There are just a very few exceptions, for example, 245I, or if, for example, somebody qualified and received parole in place. And this way, they're able to satisfy that very strict requirement of being paroled prior to the adjustment of status. But in all other cases, if the child is too young, perhaps, or if the parent has other independent issues, for example, they had criminal past or some immigration issues in the past that prevent them from being admissible with regard to that green card application, just because they have a child born in the United States, it would not guarantee them status in the United States. Another important issue to remember that if a child is born in the United States, but the parents were diplomats at the time of the child's birth, such a child is not going to receive automatic US citizenship. An interesting point to know. Well, guys, thank you very much for watching. I hope you enjoyed this little video. If you did, please give us a thumb up. Please sign up for the channel. Don't forget to share this video, and I hope to see you soon.